Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to the Novus Law Firm and FortneyScott's Biden-Harris administration's first 100 days. What happened and what higher education can expect? I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, feel free to submit a question in the GoToWebinar box, in the question box. We will try to answer all questions. This briefing will be recorded. Today's webinar will focus on Biden-Harris administration's first 100 days. The presenters include attorney Natasha Baker from the Novus Law Firm and FortneyScott attorney Elizabeth Bradley. I will now turn the program over to Elizabeth Bradley to start our webinar.
Hello, welcome everybody. We are excited to have yet another session of our higher ed web series between the Novus Law Firm and FortneyScott. Welcome back, those who have been here before, and welcome to any new attendees. A little about us. FortneyScott is a DC-based women-owned law firm that focuses our practice on various aspects of labor employment law. We focus on a little bit of that DC insider approach, and with us today, we have Natasha Baker. She too focuses in the labor and employment range with a heavy focus on
Thanks, Liz. Sorry, sounds like you muted for a second there. So we are in California and focus primarily on labor and employment within higher education. And we're delighted to have yet another installment in this series of what to expect in higher education during these tumultuous times.
Great. So a little housekeeping before we jump into our topic. These materials are not intended to provide legal advice. If you have any questions or comments, you can consult either your in-house counsel or you can welcome to reach out to Natasha and I directly, and we could provide you more specific legal advice, but please don't rely on these materials themselves to be your source of legal guidance. So I think we can move to the agenda. We're going to start by giving you an overview of the Biden-Harris administration's first 100 days. What happened? What occurred?
Liz, I'm just going to pause you.
About today, is it moving? I think we have a lag.
Yeah, Liz, I think your audio might be pausing or something. So I don't know if that's just me or everyone, but I know you were saying very important things about the agenda and what has happened in the past 100 days. So Valerie, I don't know if you were able to hear Liz as well.
I did not.
Okay.
Okay, let me, can you hear me now? All right. So let us start over with that agenda. I'm not sure what's going on with my audio. We're going to start with an overview of the Biden-Harris administration's first 100 days. We're going to talk about what they achieved. A few of the points we may talk about what hasn't been achieved yet, or what they're not going to achieve. We're going to talk about the pending employment bills, what is out there, where the various things working through, approval processes. We're going to get a touch on the federal employment agencies. What have we seen them doing to date, and moving forward into our predictions of where we expect that they're going to go with their enforcement action and of their.
So Liz, I'll just take over from here. If you're,
Can you all hear me now?
Yes. Yes.
Okay. So predictions are last, and then we're going to move to takeaways. I think we can all read the agenda since I clearly can't give you the audio of it. Let's move on to the next slide.
That might be the universe cautioning us about making predictions in this era.
I think that's exactly it. Exactly. So we want to touch here quickly. Some of the topics we're going to talk about have been fully discussed in much greater detail in our prior presentations and recordings. So these are, you can request that this deck, because these are hyperlinks, or you can go out to the Novus law firm website or FortneyScott's website. We both are hosting the prior recordings on our websites for your listening pleasure. So feel free to access those. Now I'm going to turn it over to Natasha to get us kicked off.
Great, thank you. And yeah, your audio sounds great, so thanks for that. I do think that's a caution about us making too many predictions here, because the first 100 days have been quite busy under the Biden-Harris administration. But I think for those of you who attended our first session back in early January, sort of predicting what might happen under the Biden-Harris administration, it's been somewhat slower on some fronts than we anticipated, and then somewhat more chaotic on other fronts than we've anticipated. And I don't know what you're hearing in DC, Liz, but I know our clients are frustrated with the sort of chaotic rollout of some of the changes that have come forth. But we go ahead.
Oh yeah, we all saw the rush of 40 executive orders that came slamming at us, and then there has been a bit of a lull. And I think, as we're going to talk about, some of that may be getting the right leadership in place and what actions can continue. But that is where we're all seeing and feeling that.
So we're just going to sort of recap, this employment webinar, this webinar will focus on employment, but we're going to sort of recap some of the first 100 days, first with respect to the pandemic and the economy. We always like to say there's a higher ed angle to everything, right? So what we've seen is a lot of movement in the pandemic space, obviously that being the highest priority for everyone, that is then affecting how colleges and universities are able to reopen, whether they're reopening for summer school, reopening their campuses fully in the fall. But there was the appointment of the COVID-19 response coordinator, really started to see the vaccine rollout, the testing, the PPE. So some really good things there in terms of getting a handle on this. Obviously, that comes with thousands of employment law questions in terms of, can you ask about vaccines? Can you mandate vaccines? Can you require testing? What's the PPE? And so we'll talk through some of those scenarios today, but we do encourage you to look back at some of the prior webinars on sort of really drilling down on disability accommodations, religious accommodations, and understanding your obligations there. So there's been a lot of movement, which means a lot of employment law questions. We've also rejoined the World Health Organization, paused those federal student loan payments. Everyone's holding their breath to see what's going to happen further with respect to student loan debt. They've also mandated masks in all federal buildings, public transportation, expanded these access to the COVID-19 treatments, guaranteed unemployment to workers who refuse to work because of COVID-19, which is, we're hearing from a lot of our schools, is potentially impacting the ability to rehire and staff some of the non-exempt hourly wage positions on campus. They've reinstated some of the travel restrictions. They've extended eviction and foreclosure moratoriums. And really, well, I won't read the whole slide because we've got a bunch of these, but you can see where everything is driving towards reopening campuses, and then the corresponding employment questions and, frankly, employment law consequences of some of these decisions. So on our next slide, and I do believe
I think something is interesting. Something interesting to point out here for higher ed is with regard to the COVID issues. I think back to the prior slide, please. Some of the COVID issues, the reopening campuses, etc. Higher ed has kind of become the model that other industries are looking to, because you guys did it first. You had to do it first. You were addressing these issues and these concerns, how to do it right, and what's going to work in advance. So I, advise both higher ed and non-higher ed clients, and we are looking to what was done on campuses. And did it differ between state schools and private schools, and how does that work in different states? So whether it's good or bad, but you guys have led the way. Higher ed has led the way in that reopening concept.
Yeah, for sure. And and that varied regionally. Of course, some of the schools were able to reopen with a fair amount of PPE and social distancing. last fall. And so now that those that haven't reopened are looking to, well, how did others keep people safe last fall? And what were the mechanisms that were used? PPE and social distancing and testing being the primary ones. And then starting to wonder, well, how long are we going to keep that up? If we were going to reopen in the fall and there's no mask mandates anymore and people are vaccinated. But I'm getting ahead of myself, so we'll talk about that when we get to OSHA and CDC. So looking at the next slide in terms of what the Biden-Harris administration has been doing with respect to civil rights and immigration, obviously has an enormous impact on campuses as well. They've done quite a bit in this space. They've rescinded the controversial prior executive order 13950, which would have banned essentially DEI and inclusivity trainings, and they're promoting racial equity, and they're banning discrimination based on LGBTQ status. They've denounced Asian American discrimination, reversed transgender military ban, and one area of focus that a lot of campuses are asking about is reestablishing of the DACA protections and what's going to happen with DACA. So we'll talk a little bit about that in a bit. And then, of course, they ended the Muslim travel ban, which was impacting the return of potential faculty members and others on campus. And then, of course, as we will talk about, they announced an intent to review those Title IX regulations. So a lot going on in this space. Liz, I don't know what you're seeing in terms of focus, but we're seeing a lot of chatter around, obviously, the Title IX regs.
Right. I mean, I think what we're seeing is a deep sort of a sigh of relief about the clear embracing diversity and inclusion and embrace. So, I mean, I think it's with the executive order 985 that repealed 13950, which was advancing, racial equality and support for underserved communities. And then following right on that was 13988, which has been described as one of the most substantive, wide-ranging executive orders ever issued by a president with regard to sexual orientation and gender identity. So this is, and then denouncing the Asian American discrimination and reversing transgender. So I think this is just pushing forward that diversity and inclusion is no longer just going to be a subset of HR that is coming from the top down, that we are going to be embracing and advancing that across the board.
Yeah. And I know one thing that our campuses are keeping an eye on is that sort of, it's beyond HR at this point. It's got to be, mission, and I just will refer you to our last recording in terms of talking about effective DEI practices, and then just adding the DACA update. In Biden's first joint session to Congress, he called on lawmakers to extend citizenship to more than 11 million undocumented immigrants, or act on separate legislation to secure protections for beneficiaries of DACA. So I think we're going to see some more movement there. I think people thought that might move along a little more quickly, but that's another area that we're watching carefully, because that's something that our campuses feel very strongly about. I think our next slide will just wrap up all the action that's been happening. So
we're going to detail on it.
Right. A lot of other presidential actions, just to be aware of the freezing of the midnight rules, reversing of the prior administration's regulatory rules, and a lot of other, again, won't read the slide for you there, but a lot of things that really, I think, help us forecast the importance of civil rights, the importance of diversity, equity, and inclusivity in this administration's agenda.
And I think one piece on this slide is the third one down, is the the undocumented individuals being included in the census data. And what's important there is, kind of following the thread through, is when you are comparing for federal contractors, when you're doing your affirmative action plans, and many of you probably are, you're comparing your workforce representation to what the availability in the community is, so the availability data. Including undocumented individuals into that census data is going to increase the amount of diversity in the census data, which is therefore pushing, when you compare your current workforce with the availability, it is going to be pushing up higher diversity availability numbers. So hopefully that you will be working to do outreach and recruitment to increase the diversity representation within your workforce to match that.
Yeah,
Again,
yeah, really good point.
diversity and inclusion with this, with the administration.
Yeah.
All right, moving on to the next slide.
Okay, so now we're going to take you through some of the pending employment bills. Obviously, this is congressional action, not just specifically Biden and Harris, but it does sort of all play in together in terms of what to expect coming out of this administration and things that we are watching very closely. So I think in one of our prior webinars, we discussed this, but the Equality Act is now pending. It's passed in the, it's passed in the House, pending in the Senate. If I had a crystal ball as to what was going to happen in the Senate, I think I would exercise that crystal ball right now and start making all sorts of predictions. But, I think that's still an open question. Or not one that we can credibly opine on, because I don't think we actually know what the Senate's going to do on a lot of these, what's going to happen with certain procedural mechanisms. But the Equality Act would ban discrimination in employment, public schools, housing, credit assessments, juries, and federally funded programs. And so this would be a broad-ranging LGBTQ protection that would, many states already have these protections, but this, of course, would be at the federal level and then in places of public accommodations. And it would specifically, depending on how it gets passed, could specifically circumvent challenges under the Religious Freedom Restoration Act. So, remains to be seen. Again, I think that if you don't have state law equivalents that ban discrimination on the basis of protected categories, including gender expression, gender identity, sexual orientation, and you haven't looked at Bostock, then, if you're in one of those very limited jurisdictions and you're still haven't passed that, I think that would be applicable. But for what we've seen in higher ed, unless you're really invoking a religious exemption, this would supplement protections that already exist. So I think we'll move to our next slide. I think we're just going to bump you through some of these. The PRO Act we have mentioned before, but again, we're still watching this one very closely. It's going to have a lot of impact on union organizing. Liz, I think you were going to take this one.
Sure, yeah. I think, there's a few, we did talk about this on a prior one, but I think, again, this is passed the House, pending at the Senate. My probably broken crystal ball, I don't know, but I do not predict that this will be passed as it is. I do think that maybe this action is to be taken. I think we talk about this a little bit later in our predictions, but through executive order. But I think a couple of pieces that we need to be thinking about for the provisions of the PRO Act that are really going to be potentially impact higher ed. And it's further down on this list, but it's these micro units, something you need to be thinking about. If you're not currently unionized, this could be coming. And I think micro units are coming whether the PRO Act in whole but comes in or not. But you could then it doesn't have to be all of your faculty. It can now be the faculty in one school, potentially at one department, and then they unionize. And you can start having these small micro units popping up. So there's some concerns there. Also, the NLRB can have a different definition of, and we're going to talk about joint employer and independent contractor, but they're working through, there's definitions of joint employer and independent contractor here for the purposes of who can unionize. And that we're definitely thinking will be leaning towards the ABC test, the California ABC test. And another interesting part of the PRO Act that I think could be very detrimental to higher ed, any industry, but higher ed, is the intermittent picketing that would be permitted. So your faculty, if they want to unionize, or could just randomly decide to not show up to work and do it in an intermittent fashion that really causes a stop and start and makes it difficult for you to bring in replacement workers in order to anticipate the need. So again, it has passed the House. It is pending at the Senate, and we'll see what happens with that. But I'm not predicting that it'll go through as a whole.
Yeah, and I think what is so interesting about whatever happens with this act is it also feels like some of the other sort of fundamental concepts of labor law are up for debate right now. For example, faculty have long been able to, or have been prohibited from unionizing if they're full-time faculty and they're part of shared governance because they're considered managerial under yeshiva. And so, you know, that I think we're going to see some runs at yeshiva to see, particularly with the pandemic, there have been a lot of concerns about the remaining existence of shared governance, where decisions made top down, if things are financially driven, who's making those decisions, does that managerial exception still hold up? So we talked about this a lot in the specific, I think it was the February recording on higher campus labor updates for higher ed. But I think the yeshiva thing and then the micro units, as Liz suggested, we're already seeing unions taking a run at really starting to really carve out, you know, well, we probably couldn't get that whole department to organize, but we can get this subset or this program to organize. So we're personally seeing that already.
Yeah.
So anyway, if you're interested in that, I think the February one covers that in detail.
Perfect. And next, so the next one we would talk about is Paycheck Fairness Act. So again, passed House, pending Senate. Is anybody else noticing a theme here about what's going on? And this would amend the Equal Pay Act. Pretty substantive amendments are expected. The definition of establishment will be broadened. Currently, you essentially have to be working in the same building with the employee. It would allow you to be doing the same job but at different locations. That's just kind of modernizing the act in a way, understanding that not everybody is sitting right next to their peers, especially now. I mean, I don't know who's sitting next to their peers in the same establishment, right? It's also going to modify the factor other than race, making it has to be a bona fide business necessity factor. They'll take a run at that and able to challenge that. Strengthening the remedies, adding in punitive damages were not there before. It's also just sort of easing the way for plaintiffs to bring class actions. That's some of the other, additional provisions. So again, passed House, we'll see what will happen with the Senate. A couple provisions are already in place. For example, the prohibiting retaliation for talking about and discussing your compensation. While it's not under the Equal Pay Act, it is considered concerted activity under the NLRB. So whether it gets through the House, some of the provisions are already in effect through other avenues. I think pause point on the Equal Pay Act. I'm seeing significant discussion coming up about faculty pay, and there's a lot of talk about a lot of press articles, discussion about pay equity for faculty members. So that is whether the amendment is necessarily passed. I think this is something that higher ed needs to be focusing on and thinking about the pay of your employees, all employees, but I think faculty is going to be a focus that you are going to see continued focus on. Sorry, pregnant workers.
Yeah, and just to remind everyone to drill down on that further, the first webinar that we did this year, sort of predicting where the Biden-Harris administration would be going. The second part of that recording is, I think, where we talk a lot about, we think this is going to be a huge priority in terms of looking at pay equity. And so there's a deeper dive in that session. And I agree with Liz, this is coming up on campuses all over. And we're not just faculty, and it's the pressure point of reducing salaries, reducing payroll costs because of COVID, because of low enrollment, and then correspondingly on the other side of the meeting having to say, but we actually there's a bunch of people we need to increase because we've got an equity problem here. So it's a really challenging problem. It's one, just as a tip, that I would have many of those discussions protected by privilege rather than by a consultant. Because there's often a lot of admissions coming out of those discussions about why something or how a department got to be a certain way. So I just be careful there.
Yeah, so, a horror story on that is we have had, higher ed that they they meant well, and they published it. Their faculty members were kind of joined together and did the study, and it ultimately had to be disclosed to a government entity, and it was not always the greatest content and some information that was in there. So be careful with doing those.
Okay, and then for our last round out of things we're watching is the Pregnant Worker Fairness Act. Another one that's been proposed would impose an affirmative obligation on employers to provide non-disability workplace reasonable accommodations to women with pregnancy-related limitations. And so employers would have to provide this up to an undue hardship, couldn't force someone to take leave, and interestingly would cover both applicants and employees. So again, I think another area that we're going to see, just trying to zoom out to 30,000 feet here. So the states have done some states have done a lot of work around pregnant worker protections. This obviously would be at the federal level. And I think this is running straight into the dialogue around just how we treat pregnant workers. Can we require them to be vaccinated? What if they are breastfeeding? Can we require them to be vaccinated? And not just pregnancy, what if the elementary schools haven't reopened yet? Can those people be permitted to work from home? So I think there's going to, we're at an inflection point of how do employers help pregnant and parenting employees in the workplace. And I don't know if that's going to come through legislation, if that's going to come through the unions, if that's just going to come through general societal pressure, but it's popping up daily. And I think like when we see bills like this get proposed, it just reinforces sort of how employers need to start thinking about the demands that are coming their way.
What I find this is attempting to solve a problem here, right? And so if you think about this, is we talk about the wage gap. What causes the wage gap? It's not pay discrimination. It's mostly more men at the higher paying jobs than women. It's where your employees are in your workforce. What causes women to be in these lower paying jobs? What causes, maybe they've had to leave the workforce in order to care for children during pregnancy and etc. So rather than trying to address this at a compensation level, which it isn't really, let's address how do we keep women in the workforce? How do we allow them to develop and get past the sort of ceiling or bar that is happening just because due to the, family related pregnancy and other family related matters. I think it's interesting to start watching this. Let's develop female workers rather than trying to come in from the outside and solve it top down. It's solving it bottom up.
And then I think that leads us nicely into our next slide, because we're going to update you on the agencies that will hold you to these concepts if not done voluntarily. So we've got updates for you on the EEOC, the NLRB, OSHA, Department of Labor, OFCCP. So we're just going to take you through some of those. Obviously, for a higher ed webinar, one of the ones we're watching closely, and this is in the employment space. Now that Title IX explicitly covers employees, we always thought of the Department of Education and its enforcement unit, OCR, as sort of covering student-related or participant-related claims. But now, as with the Title IX regs, this is clearly in the employment space. So the changes that we've seen most recently within the past few weeks, Catherine Lehman is the nominee for Assistant Secretary of Civil Rights. I wish we could do a poll. How many recognize her name from the prior, for the Obama administration? She was the Assistant Secretary for Civil Rights at the Department of Education when a lot of the prior Dear Colleague Title IX changes were implemented. She had sort of a frosty relationship with higher ed throughout the latter part of her tenure, and I think that's putting it cordially. So, I think people saw her name pop back up and sort of can start to, this is a sign of where things are likely going, because what people have been watching is, what are we going to do about these 2020 Title IX regulations? Are they getting repealed? Well, they were implemented through the notice and comment regulatory process, so it's not just as simple as yanking them. There was an EO to review the Title IX regulations back in March. They've announced the June public hearings. I think it's like 11 days of Zoom hearings. I have some friends who are like planning to attend the whole thing. Like, if you really want to do a deeper dive on what OCR is going to do, like, it's probably in those public hearings. But, you know, it'll be interesting. You've also got a lot of court cases talking about due process. You've got California's got the writ process. Like, I'm not convinced I don't know that it's going to be a wholesale repeal or modification. I think they'll chip away around at the edges. One of the things I'm personally hoping for and trying to call for is to get employees out of this, because they're under Title VII. That's a, you know, totally different process. But I think they may remove cross-examination requirements, but I think procedurally it would be my crystal ball, and maybe I'm just, you know, jinxing myself here, that we're not going to see enormous changes that people are expecting to see. The other just thing to point out here in terms of OCR, Department of Education's got a 41% proposed budget increase. A lot of that is for grant money and students, but there's a 10% increase for OCR. So those of you that have had OCR open claims sitting around for 2-3 years, those of you that have had regions that are understaffed after people left during the prior administration, we anticipate a renewed emphasis on enforcement with this budgetary increase in the restaffing, particularly as we move forward. So that's the update on the Department of Education, and now we're going to look at the other sort of true employment agencies and just kind of walk you through that. So Liz, I think you were going to talk about the OMB.
Yeah, so OMB, as we talked about a little bit previously, the OMB froze the, quote, midnight regulations. These are the regulations that the Trump administration pushed through right on the eve of us walking out the door. And a few of them that were, I mean, there's a whole list. I think I counted, there's like 104 or something for various different, not related to employment. But the key ones that I think, and we're kind of tired, you're probably tired of hearing us say this, but the independent contractor regs and the joint employer, those, you know, were other ones. Other key ones that I think have an impact or having an impact on higher ed is the H-1B visa lottery, because in replacing that made priority to giving H-1Bs to the highest salaried type positions. And related to that was the restricting the skilled the highly skilled visa workers to only based on the by raising the minimum wage, minimum salary level. And that, you know, was limiting the ability of some higher ed to get the H-1Bs and those skilled laborers because of the salary level, especially some state higher ed don't pay up to some of those others. So those are having some impact on those. But, we're going to talk through, as we go through each of the agencies, some of the other midnight regulations that were frozen and are no longer in effect. So I think we can move on to the next slide.
So this one is me, and I'm just going to follow up on, so I was talking about how there's proposed funding for the Department of Education and specifically for OCR, and there's also proposed additional funding for the Department of Labor. So the Department of Labor received $200 million in the American Rescue Act for enforcement. They're proposing to add $10 billion for enforcement agencies to replace staff, 14% increase in funding for the Department of Labor. So that's apparently 1.4 billion above the last year, 2.1 billion for wage and hour, OSHA, OSCP, and then budget hikes proposed for all civil rights offices of all federal agencies. So again, this is where just harkening back to our theme of the emphasis on worker rights, civil rights, and now the corresponding desire to fund that, enforce that, make sure those agencies are staffed up is coming through clearly in these budget proposals. So lots of employment law happening, lots of employment law.
The lighter, friendlier approach is kind of going to be gone, especially when we'll talk about with the other agencies. But remember that enforcement is coming. So we need to be, regardless of which of the laws we talked about become effective or not, existing, we need to be in compliance with and start looking at your practices there.
Yep. And then just to, speaking of restaffing, we've got the Department of Labor leaders being confirmed. Hopefully you've all seen these in the news. Just one that I would flag that I think is going to be one to watch for in higher ed. Doug Parker was nominated for the OSHA Department Secretary. He's from Cal OSHA, which has had pretty extensive COVID guidelines, pretty extensive COVID standards put into place. And so there's a lot of speculation that he would be bringing those. Now, the crisis may evaporate by the time he gets nominated to OSHA, but that's just one that I wanted to flag in case you weren't aware of that particular background. So I think we'll leave you with that. Oh, go ahead, Liz.
A couple that Marty Walsh, again, it comes from, and we mentioned this before, but strong union background. So that I do think that the unionization and the concept of employees in that mindset and looking at them is going to continue across the agency. I also think the wage and hour administrator is going to be an interesting one to watch. He really does come in, and this goes back to the independent contractor. He thinks everybody is an employee. The concept of the use of the independent contractors, and also is going to be leveled, and we'll talk about that more. But he is going to be an interesting one if he actually does become the nominee and is put in place. So he is, I think, definitely somebody to watch because wage and hour, that's across every category of your employees, and we'll be touching on that.
Yeah. Okay, so if we go to, I'm just going to do we probably need a whole separate webinar on this topic, but what OSHA, the federal OSHA is doing, we've also got Cal OSHA out here that we're watching, but the OSHA's emergency temporary standard, which would regulate COVID restrictions and safety requirements, was submitted to OSHA.
Where is that?
Where's what?
The emergency standard. I was joking.
Oh yeah. I thought you meant where is OSHA, and I was like, well, I guess it's in DC, and that's where you are. Okay, we'll cut the employment lawyer jokes here. We'll cut it out of the recording. So yeah, the long-awaited, it's not available for review by the public yet, and so because the CDC, in the midst of this, announced it's, you don't have to wear masks anymore guidance. There's a lot of confusion right now about who has to wear masks, who has to wear masks in the workplace. But the CDC carved out workplace rules from its newly relaxed mask guidance. And so we don't expect, if OSHA were to come in and issue an ETS that has specific mask wearing or PPE wearing guidance, that would control. But we don't expect that they will be contrary to the CDC at this point, given the way the numbers and the vaccination rollout is going, harkening back to our first slide about Biden and Harris's first 100 days and getting those vaccines out and getting those numbers down. So what I would be focusing on is, if this OSHA thing comes out, what those requirements are, your state requirements, and then your local public health agencies are still probably the most restrictive out of anyone. So in the hierarchy, that's what I'd be looking for in terms of, are masks required? Are they required in the workplace? And then just a tip, because this is what everyone is working through right now, is okay, if we can relax ultimately masks in the workplace and people are vaccinated, are we going to require masks? And what about the people who aren't vaccinated? Are we going to have sort of the scarlet A on someone's chest if they're walking around with a mask on? What does that convey? So it's permissible. It's a permissible requirement because it's based on vaccinated versus non-vaccinated status. But if you think about how a campus functions and how people interact and the dynamic there, that would be something that I would work through before you impose your own discretionary mask mandate once they've been relaxed further by the agencies.
I agree. I think another enforcement point on OSHA, I just want to kind of, before we move off to OSCP, a point on OSHA is in February, the DOL's Office of Attorney General, Office of Audit, issued a report that was highly critical of OSHA and made various recommendations to which OSHA, agreed with concurred with 4 of them. But specifically, they are reviewing their inspection, prioritizing moving to very high risk employees with COVID and inspection protocols and how to go through those inspections, and also looking at whether they're remote inspections versus to on-site inspections and the success of those and the findings of those. So that just goes back to putting some of the slides together of the increased budget for OSHA, the report saying you need to be looking at your inspection tools and processes and monitoring the success of those. So OSHA inspections more are coming. There's going to be a change in how those are done. So be aware of that, that we anticipate that to be coming. So
yeah, great.
OSCP now. All right. OSCP is one that's sort of wait to see. Sorry, there has been some agency action, and I think it's important to note Director Yang didn't need to wait to be confirmed. Remember, she was in place, and I think we've talked about this on our prior ones. Within an hour of President Biden being sworn in, she was in place. So she has been there. She is kind of focusing on developing and working and making sure there's transparency in hiring and pay. That's what she wants to see from the contractor community. She also stopped, there was under the CSAL, Corporate Scheduling Announcement list, was a number of these focused reviews that under the Director Lean, they're going to go in, look closely at specific issues, for example, promotions, and then go in, look at that, and get out. And the point was to do these spot checks on specific items. She has pulled and removed all of those from the CSAL list, so they will not be doing this. She's going back to full compliance evaluations, not limiting it to specific topics. Also, they indicated they will be rescinding the religious liberties regulations. So there's, I forget the date, I think it's May 28th, where they need to, there's 2 lawsuits that are related to these and then need to be giving comments. And I think that they're going to be recommending that they be rescinded. And also, we already touched base on the rescission of 13950. One thing I want to point before on this is what we're seeing with the agency. And while Director Yang appears to be focused on developing transparency from the contractor community, I'm not sure we're going to see the same level of transparency that we had under Director Lean out of the OSCP back to the contractor community in audits. The transparency directive is still out there. It's still in place. I don't think Director Yang can pull it without getting significant negative reaction to that. But I think she can limit the level of transparency. So what we're seeing is the agency asking for more data in compliance evaluations and not being as open with contractors about the indicators they're seeing in the data or the reason why they're asking for the data. We also see that in response to that, pretty quickly, the contractors can push back a little bit, but we're seeing them quickly pull the denial of access card, that if a contractor is not willing to give the information, the agency is saying, we're going to go to the solicitor and do a denial of access. And that's the solicitor's office kind of likes those. It's pretty easy, because if you say no to data, it's easy for them to prove. So it's kind of a piece that we're going to want to be looking at. And that's what we're seeing from the agency. But we have a question. Let's see if it's about this topic. Nope. Okay. So moving on, the next slide about OSCP, and this is the real thing that everybody needs to be looking at. This is the kind of hot item coming soon. So the agency has announced affirmative action. They have an affirmative action plan verification interface that says coming soon. Federal universities who are higher ed, who are federal contractors, are going to be required to submit a verification that they are in compliance with not just that they have AAPs in place, but they are in full compliance with all of 41 CFR Part 60. Those are pretty broad obligations. And so what's interesting here is the agency has never required this before, but when you're doing your SAMS registration, you are making certain certifications there. So, but often that's being done by procurement, not really double checking with compliance to see, are you in, is this happening? And we do believe that the agency is likely going to use these verifications as a way to modify their audit selection process. And we don't know exactly how that's going to roll out, but assuming somebody does not certify that they're in compliance, that might trigger them to be subject to a compliance evaluation. So it's really important that before you check the box for this, if you're a federal contractor, you need to be keeping an eye, when is this going to go live? And you need to be looking through your current compliance programs, and do you meet the requirements necessary to say, yes, you are, because it's going to be somebody, the most senior person in your organization is going to be certifying that you're in compliance. So this is sort of a big deal. So this is a piece that any of you federal contractors need to be looking at.
And just as a reminder for everyone on the call, just because you are a Title IV participant, just because you may receive grants from the federal government, that does not make you a federal contractor. So really just, and I think it was in that, maybe, I don't remember which recording, but we did a deep dive on how to assess whether you're a federal contractor and thus subject to all of these requirements. But as Liz is saying, this is going to be an enormous obligation, so you're going to want to know that. And we do often caution our schools to watch out. Sometimes people opt in and say that they'll comply without really realizing the consequences of that.
Exactly. All right.
So I think the next one is me, and so wage and hour, so impacting every aspect of our employment workforce. So as we talked about, and as I think is on everyone's radar, is the proposed rescission of the prior administration's joint employer rule, and then the wage and hour issuing the final rule rescinding the independent contractor rule on May 6th. So what we're specifically watching for in higher ed is, when are we going to be considered a joint employer for purposes of wage and hour? As Liz alluded to earlier, I love it. There's different definitions of joint employer under NLRA. There's different definitions under wage and hour. There's different definitions under state law. But specifically for the purposes of wage and hour federal compliance, when are we going to be considered a joint employer? And they're obviously proposing a much different and easier test here, and repealing the test. So in higher ed, where we see the potential for joint employer is in some of these joint programs that we're operating. In some of the, depending on this is where you want to check your contracts to see how much control you have over another entity's employees. So some research agreements, some like Sodexo, Bon Appetit, those types of things. You're retaining a lot of control over those employees, that other entity's employees, for risk management purposes, but be careful about whether that will then run you up into this new joint or will be proposed joint employer rule. And then, of course, on the independent contractor rule, the proposal is essentially to use the California ABC test, which now year after year is starting to have more and more exemptions. But again, this is where we see higher ed use a lot of consultants. And so really, if the California ABC test rule were to pass, depending on how it's worded, depending on the scope of it, because it had to morph in California to allow for consultants again, that your classification of many of the independent contractors you bring to your campus would need to be vetted through procurement again to make sure that it follows this new test. Both of these are proposed. If this goes down, if this happens, we'll do a separate full briefing on what that actually is. But just what I urge you to do right now is think about where you're vulnerable. And so we have a lot of different types of positions on the call. But what I see from my vantage point, which is the legal vantage point, is people are authorized all over campus to enter into independent contractor agreements, to enter into joint programs. I would be looking to centralize that, particularly as we move towards more permissive interpretations of joint employer and independent contractor. Some schools have said only procurement can vet these. You know, your department can't set this up. Thank you very much. So I would take a look at that, because I think there's a lot of it's been ad hoc for years, I guess is the best way to say it.
Yep.
So oh, did you want to? Sorry.
Oh, I'm waiting out. Yeah, sorry. Go ahead. A couple things to chime in if you're done.
Yes.
Okay. I think another change, wage and hour. They did eliminate, or they terminated the payroll audit independent determination paid program, which was a program in which you could self-report wage and hour violations and avoid audit activity. So that program is gone. So in case you were thinking about acting under that, the Biden administration has eliminated that. In addition, back to the federal contractor world, they did increase the minimum wage for federal contractors, and that is back up to $15 an hour. And that is going to have, beginning January of 2022, then beginning in 2023, that federal contractor minimum wage will have annual increases based on the consumer price index. So you should be looking at if you are a higher ed entity that is a federal contractor, you need to be looking at that hourly workforce and see how many are below that $15 amount. Then tie that in with this joint employer categorization, and or independent contractor, and how is that going to play together? Are any of those individuals being paid less than $15 an hour, and are you going to be dinged a potential violation there? So there's a few of these pieces that you need to consider connected to each other.
And then tie that into your pay equity audit. And then tie that into your budget deficit from COVID and low enrollment.
Exactly. It's a good times we're all about to have. Moving on to EEOC.
Speaking of good times. Okay, so the EEOC, again, changes to leadership. We're seeing a little bit more outreach. They had their first virtual meeting on workplace civil rights implications of COVID-19 pandemic. That's because employers were desperate for advice on what they wanted the EEOC to opine on. They haven't recently issued any additional guidance on the use of incentives for vaccines. Recall that they were sort of looking at that back in January, because the concern was offering an incentive for a vaccine might violate some of the benefits laws in terms of trying to get people to take health care based on if you will, bribing them into doing so. And then they haven't opined on requiring vaccines for returning to work. My prediction here, they're going to stay out of it, right? Like at this point, you've got the CDC, you've got OSHA, you've got states, you've got local guidance. I think that they're saying they're working on it. I feel like that's what all these agencies have been saying. I know in California, we haven't gotten updated higher ed guidance since last September. So I feel like the trend right now is to say like we're working on guidance. I mean, I don't know. This is my opinion from my spare bedroom, but that's what it feels like in terms of what these agencies are doing, because the timeliness of the guidance has been a concern, which leads back to this first point about the employers asking for more guidance. And then, of course, the conciliation rule is gone, so that was invalidated.
Yep.
So, yeah. And then I think I'm going to move to the next slide to keep us on time here. So the EEO1 Report Portal is open. You do need to submit your 2019 and 2020 EEO1 reports by July 17th. And then a couple personnel updates with respect to the EEOC. Vice Chair Jocelyn Samuels has been renominated for a second term. And I think if you recall, one of our discussions in that January recording was sort of about how the EEOC staffing is slightly different than some of the other agencies in terms of partisan appointments, in terms of the terms of people. But we're re-seeing that renomination, and then the GC is gone. Sharon Gustafsson hasn't nominated a new GC, general counsel. There's someone who's acting GC, Gwendolyn Young-Reams, who's sitting in right now. So yet another reason why I think they're not going to weigh in on like the mask or mandating vaccines.
Yeah. So I will say it has been announced that they're looking to increase, EEOC is looking to increase their staff by approximately 450. What does this ping back to? Enforcement, right? And so you're going to see a lot of additional activity by the EEOC, especially when they get that additional staff. And I also see them probably activating an MOU they have with OSCP, and some of that EEOC maybe help sharing some of the load with some of the OSCP work. I could see them partnering together based on the relationship of the chair of the EEOC with the new OSCP director. But we could do a whole session on that. So, but to keep us moving, we're going to flip to the last. We can move to the NLRB. So there's a little bit of turmoil here with it, a little bit. So what Biden terminated the general counsel, and there's a lot of legal challenges about that, about whether or not the termination was legal. And so we're seeing a lot of challenges to the actions by some charges that have been raised by the NLRB since putting in the acting general counsel. Jennifer Abruzzo, who is the nominee, has yet to be voted on by Senate. I kind of think that a lot of this is going to churn, and legal challenges are going to be coming up to any activity they take prior to November 2021, when Rob's appointment would have been up anyways. So we could spend a lot of time on this, but we don't have it right now. But I don't expect to see a lot of activity out of the NLRB until November of 2021 because of the legal challenges over the removal of the general counsel.
Right, which is not to be confused with action under the PRO Act and sort of those labor things. This is just specifically the types of decisions that the NLRB will be issuing that it could be later reversed on because of the procedural concerns.
Correct.
Okay, so Liz, we've got like 5 minutes left for our predictions. Now your audio
3 minutes left.
3 minutes left. Your audio cut out when we tried to mention predictions before, so I think we should just give it a go and see what happens.
Right. So I think we've already talked about many of his executive orders were already rescinded. I think we can move that movie we've hit on. We've seen it happening, and there we are with that. Opinion letters. Some of them are coming out. Some of them are not. Guidances. Some of them are not. Some, any of them, like I mentioned, OSCP. The transparency guidance isn't coming out, but it may not be enacted on in the same way.
Right. And then the regulations being halted if possible, right? So recall that the review of everything was ordered, but if possible, yes. And as I think we've all seen, particularly those that are focused on the Title IX regulations, walking back properly promulgated regulations is not an insignificant procedural task. For those that were pending and hadn't made it through that process, that's of course a different story. And you do have more flexibility there, the administration does. But for those that, such as the Title IX that went all the way through, we're seeing what that process is going to be to look like to walk back. So, these are some of the questions we flagged in that first sort of back in January. What do the first 100 days look like? I think, as you can see, it's been a really busy stretch for the administration. Lots of changes, but then also not quite the changes that everyone was sort of predicting potentially back in January. So, and then I think we're just going to talk about the top labor and employment priorities. So OSHA, the new regulations imminent and enforcement's begun. Expanded union rights under the PRO Act, unlikely to pass, but probably some executive orders there. Liz, I don't know if you want to jump in.
I think these are things that we've touched on before. I'd like to go to the next slide because I think that's a little bit of a takeaway or that I want to hit before we run out of time. Is any of the acts that we talked about that do not pass full,
I do see executive orders and having a lot of these additional heightened requirements, expanded obligations being placed on federal contractors. They're the testing ground. We talked about the increased federal minimum wage. So they wanted to increase the minimum wage across the board to $15. Couldn't get that passed for all employees. Where did we see it land? On federal contractors. That exact type of action we're going to see increased and repeatedly. So, and we are at time now. So quick takeaways, we'll flash the slide up for you to the takeaways. And I'll just lead off since I'm already talking. Biden has introduced the most expansive legislation agenda in years, and we're starting to see a lot of activity on that. And he's continuing to reverse many of Trump's priorities and policies, as we all expected he would. Natasha?
Yeah, and as I talked about in my Department of Education and Department of Labor slides, there's money behind it for enforcement. So I think we're going to see enforcement that we haven't seen in some years due to either the prior administration's priorities or due to lack of funding due to the recession in the Obama administration. So there's money to enforce this in ways that we haven't seen in a while. And then, of course, as Liz just explained, where things cannot get passed, there's the tool of the executive order for these types of priorities. So thank you all for joining. I think we probably now go to our closeout housekeeping script, and we'll see you again next time.
Thank you, everybody.
We would like to thank you for joining us. As a reminder, you may view previous briefings on both the FortneyScott and Novus Law Firm websites. Everyone who registered today will be registered for all future higher education focused briefings. Be on the lookout for additional updates, which will be sent via email. Right after this program, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.